An application lordship under section for production of document is filed, lordship. Application of section 151 for direction to respondent number 3 to produce the entire record forming the very basis for the issuance of income tax. Lordship, this is a case Lordship, wide annexure P1. Kindly appreciate. Lordship. The P3, Lordship, P8, page 48. This is dated 22/9/2023. कुलपति के द्वारा परिषद कार्य परिषद के सदस्य हैं विश्वविद्यालयों के अन्य अधिकारियों से डॉक्टर सुनील कुमार राठौर के कार्य व्यवहार व आचरण की शिकायतें विश्वविद्यालय के हितों के विपरीत पाए जा रहे क्रियाकलापों को दृष्टिगत रखते हुए इनके विरुद्ध की गई अनुशंसा के परिप्रेक्ष्य में विश्वविद्यालय के हितों को दृष्टिगत रखते हुए मध्य प्रदेश आयुर्विज्ञान विश्वविद्यालय अधिनियम 2011 की धारा 65 धारा 5 की शक्तियों का प्रयोग न तो डॉक्टर सुनील कुमार राठौर को के सदस्य पद से तत्काल प्रभाव से हटाया जाता है। Lordship, he has been removed in exercise of power under section 65(5) of the Act, Lordship. Lordship, during the pendency of the petition, the reply was filed, wherein a specific stand has been taken that exercising the emergency power, that is under subsection 5, he has been removed. Now, Lordship, I kindly appreciate, we moved an application. Along with the application, Lordship, I kindly appreciate, we filed a document annexure A1, page 8 to 26, Lordship. Lordship, this is a document which was received under RTI by one of the RTI activists, Lordship. And Lordship, I kindly appreciate, from page 9 onwards, the proceedings are there, Lordship. Now, this is the first note sheet. It starts from page 9, Lordship. And this note sheet is written by the law officer of the governor, Lordship. उनके द्वारा जो vice chancellor has sent the recommendations. All those facts have been mentioned. कुलपति मध्य प्रदेश आयुर्विज्ञान विश्वविद्यालय जबलपुर के पत्र क्रमांक जबलपुर दिनांक 19/9/2023 एंड पत्र क्रमांक दिनांक 20/9/2023 पर से प्रमुख सचिव राजभवन से हुई चर्चा के क्रम में उस पर वैधानिक स्थिति का विश्वविद्यालय के प्रशासनिक हितों के परिप्रेक्ष्य में आकलन किया जा रहा है। कुलपति के द्वारा अपने उक्त दोनों पत्रों के माध्यम से व्यक्त किया गया है कि विश्वविद्यालय की कार्य परिषद के सदस्य श्री सुनील राठौर का आचरण विश्वविद्यालय की कार्य परिषद की गरिमा के अनुकूल नहीं है और उनके कृत्य कार्य परिषद के सदस्य की शुचिता एवं नैसर्गिक न्याय गरिमा के विपरीत है। उनके कृत्यों से ग्वालियर नर्सिंग प्रकरण में पूरा प्रदेश प्रभावित हुआ है। उनके द्वारा प्रकरणों में अनुचित हस्तक्षेप किया जाता है तथा नर्सिंग इंस्पेक्टर लिस्ट भेजकर आपकी इच्छा अनुसार इंस्पेक्टर विशेषज्ञ को कॉलेज विशेष से भेजने के निर्देशित किया गया है, जिनकी उनको अधिकारिता नहीं है। उनके इस कृत्य से निरीक्षण की गोपनीयता एवं गरिमा भंग हुई है। कार्य परिषद के साथ अन्य सदस्यों के द्वारा संकाय अध्यक्ष के द्वारा श्री सुनील राठौर के साथ स्वयं कार्य करने में असमर्थता जाहिर की गई है, कार्य मुक्त करने की मांग की गई है। इसके समर्थन में कार्य परिषद सदस्यों के पत्र भी संलग्न किए गए। उक्त आधारों पर कुलपति के द्वारा कार्य परिषद सदस्य श्री सुनील राठौर को कार्य परिषद से तत्काल मुक्त करने की अनुशंसा की गई है। कुलपति के द्वारा प्रस्तुत उक्त दोनों पत्रों के तथ्य संलग्न प्रपत्रों के परिप्रेक्ष्य में देखे जाते पाया जाता है कि मध्य प्रदेश आयुर्विज्ञान विश्वविद्यालय जबलपुर की कार्य परिषद के सदस्य श्री सुनील राठौर के कृत्य से कार्य परिषद के अन्य सदस्य व अध्यक्ष कुलपति को विश्वविद्यालय के कार्यपालिक निकाय के कार्य संचालन में अत्यधिक कठिनाइयों का सामना करना पड़ रहा है। कार्य परिषद के सदस्य के रूप में श्री राठौर का कार्य व्यवहार संस्था की गरिमा के अनुसार नहीं है, वरन उनके कृत्यों से कार्य परिषद की कार्यकुशलता गोपनीयता भंग हो रही है। उनके कृत्य से विश्वविद्यालय की साख पर भी प्रभाव पड़ना संभव है। Now, my application is that now these are the documents which were not in our possession, because no reason has been assigned in the order, Lordship. And the very fact is, Lordship, that neither this order has been, Lordship, there is no application of mind by the Chancellor.
Yes, my lord, your lordship may kindly appreciate this fact, my lord. In the writ petition, my lord, they have not questioned the satisfaction of Honorable Chancellor, man. They have not questioned it. They have not made any allegation of malafide. They have not implemented any authority in his personal capacity. There is no pleading which would unfold, my lord, that they are challenging impugned action on the ground of malice in law. So, my lord, your lordship may kindly appreciate, in absence of all these facts, my lord, they cannot, my lord, make a prayer before the honorable court to direct the respondent authorities to place the entire records before the honorable court, my lord, in absence of any pleadings in that regard. Now, my lord, one needs to stand on his own limbs before the honorable court. They cannot borrow my legs to stand before the court. Now, your lordship may kindly permit me to take your lordship to the relief clause prayed in the writ petition. And for that, my lord, I invite your lordship's kind attention to page 8 of the writ petition. Now, my lord, the relief which they are claiming. My lord, got this paragraph 7, my lord? I'll just read it for your convenience. To issue a writ in the nature of certiorari and quash and set aside impugned order dated so and so in the interest of justice. This is number 1 relief. Number 2, to issue a writ in the nature of mandamus and allow to petitioner to work as he was working earlier in the interest of justice. Number 3, any other relief that this honorable court may deem just and proper in the facts and circumstances of the case may kindly be awarded. Now, my lord, no relief regarding production of any sort of records. Now, my lord may kindly see paragraph 6. It starts from page 7 of the writ petition. Now, my lord, these are the grounds which they have raised in the writ petition. Small grounds. My lord, I'll just read it. That the petitioner is a citizen of India and is entitled to protection of his fundamental and constitutional rights. Now, my lord, pausing here for a moment, your lordship may kindly see. Here, my lord, petitioner is not questioning his appointment order. My lord, he is questioning cancellation of his nomination. Now, whether, my lord, to get nominated in the body of any university or any institution, whether there is a fundamental right of petitioner or a legal right to get nominated, and whether, my lord, it is the fundamental duty casted on the university or on any institution to nominate petitioner only. So, my lord, in absence of any fundamental or a breach of any fundamental or a legal right, they cannot pray for issuance of a writ of mandamus. Now, my lord, ground number 2, that no opportunity of hearing was given to the petitioner, and without giving any reasoning or without giving any speaking order, the impugned order has been passed by the respondent. Now, my lord, pausing here for a moment, I invite your lordship's kind attention to section 65(5), whether it provides for giving any opportunity of hearing.
And they have filed it.
We have filed it, my lord, what we are saying. Ji, sir. We have filed it.
24 को फाइल 24 या 25 को फाइल
24 को फाइल करके साहब हमने ये कहा है कि आपकी कोई प्लीडिंग नहीं है इस बारे में, और साहब रिकॉर्ड तो जब कोर्ट को ऑनरेबल कोर्ट, my lord, when honorable court is of the view that something wrong is done, then, my lord, we are bound by the directions of the honorable court. My lord, we will produce any record for the perusal of your lordship. But, my lord, they cannot make such a prayer, my lord, to strengthen their writ petition. Now, my lord, बिल्कुल आप जैसा निर्देश करेंगे साहब मैं रख दूंगा.
Yes,
लेकिन सर,
yes, I said, what is the application of mind?
My lord, what the
yes, of course, because these documents are received subsequently in the RTI. Then we came to know that there is no application of mind by the Chancellor itself. I will file subsequent.
My lord, may I submit one thing, my lord? My lord, in my reply, my lord, we have taken a specific stand. My lord, reply to the IA which they have filed. In paragraph 6, my lord, we have said in our reply, my lord, that it is submitted most respectfully that the instant application for production of record is not maintainable. Now we are questioning, my lord, whether they can file such kind of IA or not.
What?
My lord, it would virtually allow the IA. It would virtually allow, it would have the impact of allowing that IA. Certainly, that's true, my lord. My lord, therefore, my lord, I have respectfully submitted. If my lord will direct us, my lord, barring this IA, if there is a direction of the honorable court, we are bound by it, and we will bow down to it. But my lord, we have raised issue, my lord, in our reply that such kind of IA is not maintainable. More so when, my lord, pleadings are missing in the writ petition. Now, my lord, there is no prayer for production of any record in the writ petition. Subsequently, my lord, on the last date of hearing, my lord, when we filed our preliminary submissions, they took time to file rejoinder. Now, instead filing of rejoinder, my lord, they have filed this IA. And now they are saying that they have become wiser after producing some sort of records. I'm not aware, my lord, which RTI activist has applied for supplying of that note sheet, which is a part of IA. But, my lord, that cannot be regarded as pleading made in the writ petition. Now, my lord, this honorable court as well as honorable Supreme Court has said, whatever is pleaded in the writ petition, that is the pleading. Now, my lord, that pleading cannot be supplemented by filing any kinds of IAs. Only, my lord, if they want to substitute some of the pleadings made in the writ petition, they need to file an application for amendment in the.
पूरा सब दिया हो.
जी जी सर सब मेरा एक जो निवेदन है सर, काइंडली योर लॉर्डशिप में काइंडली अप्रिशिएट माय लॉर्ड व्हाट आई एम सेइंग. सर पिटीशन में कुछ भी नहीं है सर. योर लॉर्डशिप में काइंडली अप्रिशिएट दिस फैक्ट माय लॉर्ड. Even a primary student of law, sir, he will be in a position to answer this question when a writ of mandamus can be issued. Now, my lord, this is the only argument which I am placing for your lordship's kind consideration. When my writ of mandamus can be issued, here, my lord, he is not challenging his appointment. He is challenging his cancellation of his nomination. Now, my lord, nomination is not his legal right or a fundamental right. And if he says that nomination is bona fidely cancelled, there is no pleading in that regard. Your lordship may kindly appreciate. Yes,
No, I kindly appreciate.
Therefore,
No, I will answer. The very first argument is that I had not challenged my nomination appointment. I think there is any person who can do this. Why he will do it? His nomination, he will never challenge his nomination. So that is not an argument which my lordship should consider. My cancellation of nomination is in contravention of section 65(5) itself. Lordship may kindly appreciate that. They reproduce the section, lordship.
I'm sorry, my lord, I'm interfering, my learned friend. Rejoinder and it may be fixed.
No, I say, lordship, my specific submission is the chancellor has not applied its mind, and that is very clear from the record. Yes, but what is the hitch? My lordship was very categorically stated that keep the records on before the my lordship. Now, lordship, illegality in the procedure can be very well be looked under the power of judicial review. Now, lordship, may kindly appreciate the complete order sheet, complete that very record is with in the RTI, lordship. The law officer of the governor is writing note sheet. Thereafter, there is no application of the chancellor. It is the chancellor who has to apply its mind, and thereafter he has to pass an order that no inquiry is needed under subsection 1 to 4. What are the reasons that chance? Yes, why it is not being applied? What are those circumstances? This is the satisfaction of the chancellor. the disciplinary authority. Now, this very provision is somewhat similar to Article 311(2), the proviso. There are three conditions. Of course, there is no guiding principle in this very subsection. But I say, Lordship, the Chancellor has not applied its mind. Chancellor has not passed any order. It is only on the note sheet that he put a signature, and it does not mean that he has applied his mind. It is required from him. And Lordship, material is such which is very stigmatic. आप देखिए सर एप्लीकेशन के साथ
प्लीडिंग होना चाहिए, कुछ बात होनी.
No, Lordship, because I subsequently came as a counsel. I understand that.
No, but they
But
cannot now.
now, why not?
They cannot.
Who they are to say these are all subsequent facts?
I'll reply to them.
No, we are there to make a prayer. We are praying before the
Lordship,
honorable
I
court.
kindly
You
appreciate.
cannot question our authority, who
No,
we
no.
are.
So then of course,
You invited me in litigation.
yeah, no, we are not invited. It is you who made the
I am
situation that
you made me respondent.
No,
No, I don't want to
yes,
play housey here.
no, I don't. Myself also not interested. Neither I had this interest. My only contention is, Lordship. No, Lordship, I kindly appreciate. Now, we are before my Lordship to say that Lordship may please lift the wheel and appreciate what are the intentions of the Vice Chancellor. It is the Vice Chancellor who is aggrieved because he is acting illegally. Within 2 weeks. Lordship.
I'm so highly obliged, man.
Stand up, Lordship.